So the thing that you mentioned, the impeccable and the peccable expert testimony, but in my mind, what I'm questioning is the expert.
Mm-hmm. Well, the expert should be questioned, and
no, I mean whether that should even have that designation applied to her.
Well, I think
that's what I'm gathering right now.
Well, I think that comes out in cross-examination from what I'm learning, and cross-examination from what I'm learning is a very important part of gathering the evidence and should be allowed. Which in the last hearing with Judge Crump, I wasn't allowed to do in terms of the evidence that was provided from the exhibits that opposing counsel presented. And I also wasn't allowed to testify due to, I guess, time efficiency. But due to that, there was insufficient evidence. So
for the sake of time, we will truncate your due process rights and your ability.
I think that essentially that's what occurred. And going back to your question directly, though, the expert, there's such a thing as the Daubert challenge. And again, this has been a very wonderful learning experience. Yeah. But
I'd like you to go into well, I don't know if you want to do it right now, but I want you to go into the Daubert challenge so that everybody understands what that is. We've talked about that. I've talked with others about it, but I think it's something that a lot of people don't quite completely understand. So if you want to go with something else first.
But yeah, I would probably say even a lot of family attorneys don't really understand. But it's been a wonderful learning experience, and I think really the Daubert is the test if the expertise is an expert in the specific questions, issues being tried in front of the trier of fact.
Okay.
So you can have this wonderful CV that, let's say hypothetically, this wonderful CV that you're an expert in all these things, but are you really an expert in the particular questions in front of the trier of fact?
Okay.
So I could say hypothetically, I'm an expert on auto mechanics, okay? And the trier of fact is talking about the explosion of tires on the Ford Explorer cases that occurred many decades ago. But I'm not an expert on that particular area.
Okay.
So under a Daubert challenge, which would involve three components, it is my expertise involves the specifics of the questions being asked.
Yeah.
And in this case, does Dr. Sherry's expertise involve the issues of child attachment? Does her expertise involve the issues of parental alienation? Does her expertise involve the issues of shared parenting?
Yeah.
The other questions to ask is, in her report, are all her opinions based upon all the available facts? And are there facts that, if were considered, would have changed those opinions? And the third thing is based on the second thing I just said, in terms of factual basis of opinions, does this make the report reliable? Does this help the trier of fact come to decisions, or does it help the trier of fact with information that outweighs any biases? Or is there such unreliability of the information or such bias in the information that it really impedes the judiciary?
And that's where when I mentioned the thing about inflammatory adjectives.
Okay, let's talk about that.
Because if you want to influence people in a certain way, you can put in a couple of adjectives, and the unsuspecting will say, oh, he made a salacious comment. Well, that is the way that it's written up, but you might just be saying, I'm bringing this to you, and they've taken what you've done as a legitimate response to a child custody evaluator, and now they've maligned you with it. And in particular, I know that it happened in the case with your son. So can you talk about that a little bit? Because it's not just among child evaluators. I've read district attorneys that are trying to defend themselves, and they put in adjectives. I'm like, if you strike out this adjective, it changes the whole narrative, the whole flavor of the narrative that they're submitting before the court or whatever. And the same thing with this child custody evaluator. If you take out some of those adjectives, which are designed to, play into the hand of a family law attorney, or try to get a judge to do a certain thing. If you strike out those adjectives, it's a whole different story. But I mean, did you find inflammatory adjectives, and can you comment about that within the child custody evaluation report that Alyssa Sherry provided?
I can. There was comments made that I had made several salacious accusations of sexual abuse.
Did I say that right? That's salacious.
Salacious,
Yeah.
salacious.
I'm sorry. Okay, got it. Go ahead.
Yeah, and the fact is, no, that what didn't occur. But if I was just reading the report as the truth, as an outside observer, or someone that was an adversary in an adversarial position, that would inflame the case even more.
Right.
You know, it would inflame the parent even more, the other parent potentially
Yeah.
even more. You know, but the truth was there was an issue that came up, and by our son, I was concerned about it. I did not believe it rose to the level of reasonable suspicion of abuse. I thought it was not good decision making.
Right.
But I think it had been taken care of. And so Alyssa Sherry, I guess in the report, accuses me of not reporting, but at the same time, she had ample opportunity to interview the child about the incident, and at the same time, she didn't report. So apparently she didn't think there was a reasonable suspicion, or she was defending the other party. I think another issue that she stated, 2 forensic interviews. Well, that's a lie. There weren't 2 forensic interviews, because, I mean, anytime there's a forensic evaluation by DFPS, the parents are going to be notified. There's going to be a due process, so to speak, right?
Even with the FPS?
And so there's no documentation. There's no even the existence of 2 forensic interviews. There would only have been the existence of 1 forensic interview. But again, if I was an adversarial parent and I was reading this, and I thought that the custody evaluator had uncovered some magical secret that, you know, I didn't know about, of course that would inflame me.
And I think that what you were just talking about, the term adversarial parent, what we forget is that this is an adversarial system that actually encourages people to be adversarial and to inflame things.
Well, with the exception of mental health professionals.
Okay.
There's probably many exceptions, but one of them is mental health professionals. A mental health professional should not be an advocate of creating an adversarial situation.
Right, yeah.
They should be in a neutral position, evaluating the overall situation.
Yeah.
Okay? And the recommendations should be to the benefit of the child, not to the potential harm of the child or to potential harm of the parents.
Yeah.
I mean, just yesterday you heard Senator Cruz, you know, give his presentation at the Texas Values Family Conference. If I didn't get the whole name correct, I apologize. And he said, you know, the number 1 identifying issue,
predictor of success
is that children grow up with 2 parents. So, you know, the recommendations by Dr. Sherry, and I understand in prior cases, she's played a part in separating children from their parents. And I guess for whatever justification, but in our particular case, I believe that there's no justification for doing that.
Right. And I've heard for the most part from the people, there may be one exception, but from what I've seen about Dr. Alyssa Sherry, she almost always recommends something that would eliminate or minimize the interaction of another parent. Are you familiar with any of those reports or the allegations made?
I'm familiar with the allegations, and in our case, I think it's a very destructive, incorrect recommendation.